allegations Untitled in the matter of Benyatov and Credit Suisse Securities Europe Limited,
Yes, Mr. Chume. Just before you start, two pieces of housekeeping. Since we've started at 9:30, everyone will be dead on their feet by 1. So we will rise for an early lunch at a convenient moment from 12:15 onwards, maybe 12:30, but that sort of time. And it will be a slightly shorter lunch because instead of having to rise at 3, as I thought, we will have to rise at, say, 10 to 3. So we'll have a truncated lunch, so you won't lose any time.
Thank you, my lord.
Yes.
Right. We've got the article and so
yes, I saw that. That's very nice of you. And in fact, embarrassingly, we didn't read, or in my case, I didn't read the email properly, so I had it printed, but my lords didn't. So if you pass up 2 copies. Thank you for the detail also of Professor Courtney's book.
And this is there's also the cover page from Hallsbury showing who the editors are.
Oh, that's very thoughtful of you. Thank you. Let's see who they were. Yes, I see it, Smith. Yes. I had one point I wanted to ask you at some point about indemnity. I don't want to put you off your stride to other things you want to say first, but in a sense it might be worth dealing with it now so that I don't interrupt you later. Is that... Did you have things you wanted to say before you got going?
No, I obviously, as one does, I started to think about other things I might have said. And then I decided I wouldn't say any more because my time is limited. I was going to stop talking about indemnity and move to the other points. But I'm happy to try and address an additional point.
Well, it's a simple point, really, or at any rate, simple to ask. When, under the indemnity which you plead in either of its forms, did the cause of action in relation to loss of earnings subsequent...
That's why do they? What's the problem?
isn't it 3 copies of the same thing?
Yes, but Justice Underhill has already got a copy. So it's 2 copies of that and 3 copies of that. So
this is all you gave me. Is this?
Yes, that's fine. Yes. Yes, so everyone gets one of those, and then Lord Justice Dean and Lord Justice Singh each get one of those.
This is in here already?
Yes.
When did the cause of action arise in relation, really, to any of the loss of earnings, but perhaps just to test it, in relation to what were pleaded as future loss of earnings in your particular claim? Thank you. When did that cause of action arise?
I have an answer. I just want to check.
Yes, by all means, see whether Mr. Legge agrees with you. I seem to have lots of copies.
The answer, my lord, is as follows. It's important to bear in mind we say the duty to indemnify is an ongoing duty. We've pleaded.
Well, quite. That's what I wondered.
Yes. So it first arose, we would say, upon the conviction. It's the conviction which is and the withdrawal of FCA authority, to borrow the expression from Spring and Guardian we saw yesterday, the kiss of death. That is when it first arises.
Okay, cause of action first. So you could have issued a writ, sorry, old-fashioned language. You could have commenced proceedings the day after the conviction, because the indemnity had been breached. What is the obligation under the
the obligation is to hold Mr. Benyatov harmless against the consequences.
Yes, but those consequences will not have accrued on the day of the conviction. They will all be in the future.
That's true, but some of them accrued fairly shortly afterwards. One at that point, if one accepts that the effect of the conviction is likely to be destructive of one's career, one might have, even if one might have sought specific performance of the indemnity or a declaration that the future loss of earnings would be covered. But
specific performance, what does that mean? I mean, the point is, this is pleaded effectively as a claim for damages. It's not pleaded as a claim for damages, but the quantum is expressed just as if it was damages.
Yes.
Pretty well all the indemnities I've come across, certainly we've seen so far in the case, are for liabilities which certainly by the date of the hearing, and perhaps at the date of the claim was issued, had crystallised. And so you could say, I have had to pay, or in your language, I have suffered a loss of £100. I should have been paid this. I haven't been paid it. So it's a crystallised or liquidated obligation. Really, I just took the date of conviction as an example. But at any point, because the loss is still being suffered every day, isn't it?
It is, yes.
So you are effectively saying there is an obligation to pay a sum, effectively a quantified sum in respect of a future loss. I've never seen that in the context of indemnity. So how is Credit Suisse to know what it is due to pay under the indemnity?
I see the point, my lord. As at the original date of the conviction, I accept that might have been very difficult. One might have been able, or suppose it's not precisely the date of conviction, suppose it's shortly afterwards when it's clear the FCA authorisation is withdrawn. I'm not sure whether it's worth fixing on a precise day, but in the past, one could have, there was loss already crystallised.
Yes, well, you can claim for that.
Yes.
Perhaps as part. Even then, there's a problem because it's not. You can't just say, "Here's the invoice for what I had to pay so and so." But at any rate, you have estimated what you have lost, and you can send a letter to them, and in principle, they can agree that's what you've lost or something else.
Yes.
It's a very different sort of exercise for the future.
I see that, but my answer to that would be twofold, neither of which your lordship may find very attractive, but the answer to that in my...
Don't undersell yourself, Mr. Jumet.
My mind would be twofold. One is to say, well, as of now, and in fact, as the time when proceedings were issued, which is 2018, it was pretty clear that this was a situation set in stone. The appeals had failed. There were some additional applications and so on, but they went nowhere. So the situation is set now, and therefore it is possible to work out, as the judge did.
Well, not work out, it's an estimate or an assessment.
Yes, but it is possible to alight upon a sum. The other is to say, well, if you think about the obligation, the underlying rationale of the indemnity being to hold harmless, meaning to prevent the loss occurring in the first place, one could say, well, that means, certainly in some of the cases, that what happens is that the indemnifying party steps in to prevent the loss happening.
How would it do that?
Well, for example, it's happened, although I'm certain that the respondents would say it's not the legal basis of their action, but it happened in two ways already in this case. The first is that despite the conviction, Credit Suisse carried on paying basic salary, which is quite a considerable sum of money, but basic salary to Mr. Benyatov after the conviction, and they only made him redundant in 2015. But he wasn't doing any work for them. So,
is there a finding to that effect?
I don't think it's...
Well, I dare say, I suppose he couldn't have following the conviction.
Exactly.
Okay, keep going, yeah.
The finding is that...
Yeah, don't keep to the point, it's my fault.
So in a sense, he was... that was a way of satisfying the indemnity. There was an ongoing duty to prevent loss, and they were...
But it wasn't satisfying.
Well, it wasn't fully satisfying it, because it was a reduced...
He wasn't effectively in a position to earn any bonus, no.
Exactly, but it was a partial satisfaction. And the other way in which there was a partial satisfaction, and we didn't get a chance to look at it yesterday, is that there was legal expenses or legal fees were paid by the bank.
Well, I see all that, but that doesn't meet the point, does it?
Well,
I'm interested in the obligation in respect to which you are suing.
Yes, but
which is not to pay the legal fees, as you say they've been paid, or to pay his salary up to 2015 because it was paid. You're suing for loss of earnings.
Yes, but what I'm trying to say is the action of paying the salary was consistent with the idea of hold harmless, preventing the loss happening. The action of paying the legal fees, particularly if we'd had time to look at the terms of the retainer, which is quite an unusual document, is that, again, Mr. Benyatov was not liable for those fees. Credit Suisse were. They were the primary beneficiary of the indemnity.
It's off the point, Mr. Achime. I'm sorry, I'm only being rather brusque with you because I know your time is precious, but it's an important point. I mean, you are suffering loss every day up to age, whatever, I forget what retirement age was taken, but say 65. A crude view might be that a fresh cause of action arises each year, each day, each month that you would have been paid and weren't paid. But that's clearly not your claim, because you're claiming the money now up front. Effectively like a claim for an unliquidated sum, which the court has to assess.
Yes.
Presumably that cause of action arises, well, I don't know. No, but perhaps this isn't a helpful exercise. You can see what's worrying me. I'll be frank, you haven't really grappled with it, and that's, you weren't expecting the point. I dare say an opportunity will arise in the next day and a half when, if you have further thoughts about it, you can address me. But you probably better get on with the points you wanted to make for yourself.
I will do. I do understand your lordship's point. I will think about it further if I'm permitted.
Can you just add to it? It may be just my perspective on what seems to me the same question. If this was a claim in tort, like a personal injury claim, it's absolutely obvious and conventional that you assess that the cause of action accrues at the moment that the tort is committed, and although loss of future earnings is a difficult thing to assess, the court has to do the best it can, and you get a lump sum until recent invention of structured settlements and so on, but conventionally you get a lump sum, and that's when the cause of action accrues. What is more difficult about the problem, which my lord put to you, is that you're seeking a contractual indemnity. Is it on the same basis as a tort claim, that you get a lump sum, the cause of action is accrued, or if it's a true contractual indemnity claim? Is it, as my lord said, something that accrues from day to day? So that, anyway, don't try and answer it now unless you have a one-line answer, but if you and your juniors can try and answer that question in due course, that would be helpful to me.
I just throw in one thought, probably better. It may well be that actually, whether you're allowed to do this, Mr. Goulding may have something to say about it, that it's the label indemnity that's the problem. You would have to say, in these very special circumstances, there is an obligation on the bank to pay a sum, a reasonable sum, if necessary, to be assessed by a court if they can't agree it, to reflect the loss of earnings attributable to him losing his principal livelihood.
Yes.
And that obligation would arise, perhaps, as you say, more strictly speaking, at the moment of the FCA withdrawal, but that wouldn't matter whether it's the moment of conviction or the moment the FCA withdraws his license. But that would be very unlike any other indemnity found in the books, and it perhaps wouldn't be called indemnity at all. You simply say it must be understood that this is the obligation which an employer in these circumstances undertakes. Anyway, there we are.
Yeah, may I just make two comments? Yes, that could be a potential solution, and that would certainly fit with the broad statements of principle about do that which ought to be done. The other thing is, in answer to my Lord Bean's point, partially an answer, we did look yesterday at the Birmingham District Land Company and LNWR case, and Lord Justice Fry was saying that the measure of damages for a breach and an indemnity claim might, under certain circumstances, be the same.
I remember you drew our attention to that. I think I'd have to look at that in the context in which it was said, but I take the point. Right, well, you better get on with where you're going to go next.
Yes. Where I was going to go next was to ground one. This is dealt with, and I'm going to sort of move forward, hopefully at a fairly brisk pace.
Yes.
Ground one, so this is dealt with in our skeleton at paragraphs 27 to 33.
Yes. He wants to go there, or is that just for our note?
It's just for your note.
Yep.
And I have three basic points here. What we're dealing with is the part of the judgment where the judge deals with the duty of care. And the three basic points are, one, we say he incorrectly applied the law in that he failed to conduct a subjective as opposed to objective assessment. Two, he failed to address...
Sorry, I have to write this down. He incorrectly law by applying a
subjective as opposed to objective assessment.
Subjective as opposed to objective.
Yes. Two is he failed to deal with the issue of assumption of responsibility by the bank.
Yep.
And three is he incorrectly rejected the very least the analogy with what's called the audit duty in Rian, which we'll obviously look at in a moment.
Okay.
Starting with the first of those, I just need to set the scene in the judgment to explain the judge's approach. We start in core bundle, tab 7, page 132.
This is deeply embarrassing. 2 days running, I've made the same mistake. Could you do your magic again with my clerk? I'll manage. I'm fairly familiar with it. Well, let's just double check. She may just put the judgment back in my bundle, but I don't think she has. No. Yeah, don't worry. I'm fairly familiar with the judgment. So.
And at the moment, my lord, I wasn't going to look at any particular paragraph. I just wanted to explain the structure of his approach. So what he does at page 132, is paragraph 149, is he says application of the above to the instant case. And just above that, 148, which starts at 130, he'd given himself a direction on various propositions of law in relation to the duty of care. So at 149, under heading E, he starts applying it. And then what he does is he summarises the parties' cases, starting at 157 all the way to 165. And then at 166, he has what he calls the overview. This is the bottom of page 135. And he divides the case into various subheadings. One was Romania was a high-risk country at the time and ought to have been perceived as such. Two, the transactions...
You need to read all these out.
No.
See what they are.
So the third one was about warning flags, which we will look at. So each of the subheadings contributed to the duty of care, and clearly we say the components of these subheadings are the basis on which he reached his ultimate conclusions on the duty of care, so they're important. The next thing that I'd like to just refer to is our pleaded case on this. It is maybe worth looking at. This is Core Bundle tab 12 at page 258. So paragraph 24.2, 24 on the previous page was the setting out the duty in terms, and 24.2 we give some more specificity, and particularly at 24.2 we say to undertake and review as and when relevant developments occurred, and at least annually a risk assessment. That is, as it were, the genesis of the judge's focus on what were variously called red or amber or warning flags. If there were material or significant developments, our case was the bank, even if they hadn't seen a problem up till then, should have conducted a risk assessment or some kind of review.
So what's the genesis? You say what's the phrase as and when developments occurred? Is that what you mean?
Exactly.
Yes, I see.
And we then, there were some examples of some of these warning, I'm going to use the expression warning flags.
Yeah.
But, as I just said, when one looks at the evidence, sometimes they're called red or amber or significant events. In my submission, it was all the same idea. The examples appear in the section on breach. If one turns to page 270 at 52.2.4, there are two lumped together there. It says adverse press coverage of the Petron privatisation from May 2006. That was one of the flags. I'm not going to look at that one, and it's the second one. And the interest of the Romanian secret police in that transaction. So what we're going to look at is the way that the judge dealt with that alleged warning flag. And it seems to be implicit in my submission that what the judge does in his judgment from paragraph 179 onwards is to pose the question, 179 is at page 141, were any of these alleged warning flags made out? And if one turns to page 141, paragraph 179, there's a heading there, but then the judge lists the warning flags, as it were, and the one we're going to look at the moment is using his numbering, number 5, the SRI investigations into Petron, June 2006. One sees that the earlier one is the Petron press allegations, but the SRI investigations, or knowledge of that, was warning flag number 5. And just by way of cross-reference, we don't need to turn to it right away. The paragraph where he deals with that is at 196. So that's the focus of the inquiry at the moment. And what we say is that two things really. We say we had pleaded knowledge by inference, and we alleged that the bank should have known. And there was a pleading point taken in relation to that. That's part of ground 2. I'll come to that later. But we had at least pleaded that the bank should have known. And the judge had directed himself at paragraph 148 sub 1, page 130, as follows. The court must consider the information reasonably available to the bank at the time of the alleged negligence. And then he quoted from the Glasgow Corporation and Muir case. Said the court must be careful to place itself in the position of the person charged with the duty and consider what he or she should reasonably have anticipated, and so on. So what we say is the focus of the inquiry should have been objective, and it should have been on the information reasonably available to the bank at the material time. We also make the nature of the objective assessment, we reinforce that point. In our skeleton at paragraph 29, we've referred to the Headley-Byrne case on that. I'm not going to go to that. It doesn't seem to me particularly controversial. So with that in mind, we now turn to the way the judge dealt with this at paragraph 196 onwards in the judgment. That starts at page 145. The section there starts at 196. It goes all the way to 201 on page 148. But the actual conclusion, as it were, is separated. Although he sets out evidence and so on in that section, he doesn't reach a conclusion. One finds the conclusion at paragraph 2263, sub 3, on page 153. And he says there, the fact that none of the alleged amber or red flags have been established. So, and in, also at 213, my lord, there's a conclusion. What my point is, and it's not meant to be a criticism of the judge, but the conclusion isn't actually in the section where he deals with the evidence. The conclusion follows at the start of 213, page 150, and he repeats it at 2263. And his basic point is at 213, page 150, he says, at the end of that paragraph, for all these reasons, the existence of this flag has not been proven. Now, what we say is that's just wrong. It misses the point. At 213, he is. It doesn't matter whether or not the pleading point of actual knowledge was a good one, even if it was, and we weren't allowed to allege actual knowledge, leaving aside the fact that actual knowledge appeared to have been found. The purpose of the inquiry here was to ask what information was reasonably available to the bank at the material time. And the judge just hasn't dealt with that at all. And we say that's obviously unsatisfactory and an error, and it's highlighted because his focus is on subjective assessment. And if he had turned his mind to the question of what information was reasonably available to the bank at the time, there's no possibility, we say, that he would have concluded there was no warning flag in relation to the knowledge that the SRI were investigating the Petron transaction. Now, I want to make that good by actually turning to the relevant document, which is the note of an interview with Mr. Rao on the 24th of November 2006. That's in.
Just trying to understand where this is going. You say it's the only possible conclusion. If we thought he had misdirected himself by looking at the wrong question, but we were not satisfied it was the only possible conclusion, at least that issue would have to be retried. Is that right? Or have we got to make a decision about it?
Yes. I don't entirely accept that, my lord, and the reason is because, in fact, it's just in the document. We're going to look at the document.
Oh, I understand that, and if when we look at the document, we agree that there's only one possible answer, and maybe I'm thinking too much like, strictly speaking, in this context, we appeal on the point of fact is okay, so we could, in principle, take the decision ourselves, not like an appeal on the point of law only. We might be reluctant to do so. Anyway, let's cross that bridge if we come to it. I just wanted to see where this was going. Your primary submission is that we should decide, and it would be easy for us to decide once we see the document, which you are about to show us.
Yes.
Which is where?
It's in the supplemental bundle at tab 5. We will need the judgments at one point, but ideally, if one can leave that open.
Yeah, annoyingly, I still haven't got mine, but so far it is not a problem. It probably won't be on this side.
There are, I want to look at this one. There's also another note of Mr. Rao that I will just turn to very briefly as I explain this. So just to explain what this document is. This is a note made of an interview between Mr. Rao and Alistair Foy, and as it says there, he was a litigation secondee from Allen and Overy. So it's a note taken as part of the bank's internal investigation immediately after events blew up in Romania into what had happened. Mr. Rao was part of Mr. Benyatov's team, and so he is therefore, although he's being interviewed after the arrest, as it were, what he's being asked about is, how did we get to this situation? So the whole note is focused on the past, as it were. He gave a subsequent interview on the 29th of November. And if we can just turn forward for a moment, there's an important point in that one. That's at tab 8. On that occasion, he was interviewed by Lee Goss and Damien Bissiker, as well as Alistair Foy. Damien Bissiker was certainly a very senior person in the legal and compliance department. Actually, it gives everyone's title there. And Mr. Bissiker was responsible for, as it were, overall responsible for the investigation. On that page, before we turn to the actual note, in that note there's an important point at paragraph 3, because Mr. Rao says this: there was a fear of the secret police in Romania. RR would suggest changes to contracts in line with commercial practice, and government officials would refuse because of their fear of personal consequences if they agreed. And then he refers back to the meeting note we're about to look at. So that was certainly known clearly by Mr. Rao. If we go back to the note at tab 5, this is the first. He gives a lot of background at the start about the privatisation of Petrom. Paragraph 8, we see this. RR was not based in Romania on a permanent basis, but he spent 70 to 90 days there in 1 year. He was spending so much time there that CS Tax were monitoring the position to make sure that no issues of permanent establish arose. The bank tried to, one of their big points was that Mr. Benyatov was the expert in Romania. He was the man on the ground. In fact, he went very rarely. His trips were very short. The person on the ground was Mr. Rao Stanchev, the contractor, and so on. So I make that point because when Mr. Rao talks about the fear of the secret police, he was clearly speaking from experience. Paragraph 16, another nugget in this. RR commented that the head of OPSPI, that's the organisation in Petrom, that's the part of the Romanian government that was in charge of privatisations. That was a guy called Dorinel Musia. He had also been arrested. That was the person to whom Mr. Rao and Benyatov had gone to have a meeting in order to help prepare Mr. Musia answer questions that were going to be posed to him from the secret police. In other words, what's important to see there is that it says DM was very well connected to the Minister of Economy and was considered by everybody to be the right-hand man of the then Minister for Economy, Dan Ioan Popescu. Turning on to paragraph 25. Appreciate this is the earlier warning flag, not the one we're looking at, but one sees Mr. Rao's view of this, paragraph 25. It says, following the change in government and the privatisation of Petrom became a big political issue in Romania, and OPSPI had to hand over a number of documents to the Romanian secret police. Aspects of the valuation report were leaked to the press, and OMV were forced to make a number of statements. OMV were the Austrian buyers of the state entity Petrom. And then we get to, as it were, the crucial paragraphs, which are 28, 29, and 32.
You want us to read those to ourselves?
Yes, please, my lord. And just while if one is reading to oneself, if one looks at 34, you can see how Mr. Rao had a close escape.
Well, hang on.
Close call.
Do you want us to read 28, 29, and 32?
Yes, please.
Right, then you can take us somewhere else after that. Yes. Incidentally, this phrase, the Romanian secret police, is that it doesn't sound very secret from this. It all seems to be. They're presenting a report to the Romanian Parliament.
Yes, I can, if I'm allowed to, I'll just explain. The Romanians have a lot of secret polices, and the principal one in the context of this case is an organisation called the SRI,
yes,
which Professor Dilettant explained.
Well, I don't need a lot of detail about it. Sorry. It's a state security organisation. That's all we need to know.
Yes, but it is quite a remarkable one in that whilst it operates in secret and conducts surveillance and so on and so forth, it also has a number of remarkable privileges. For example, it has the privilege...
Do I need all this detail? I'm sorry, I know I asked a question, but I shouldn't have. Your time is short.
I
not help your submissions.
I'll say one thing. One of its powers is the ability to conduct commercial enterprise.
Yeah.
So it is secret, but it has a remarkable breadth of function.
Yeah. Did you want to go to paragraph 34?
No, in view of the time available, let's press on. I just had one other background comment to make. We haven't looked at it, but another of the warning flags that the judge rejected was an anonymous letter sent, which Linklaters got hold of and sent to the bank's compliance department, alleging that there'd been bribery in relation to the Petron deal. And we know from the evidence at trial that that document had also made its way to OPSPI. In other words, it was in general circulation. So the key point on this is that is the sentence. Well, there are two things. First of all, Marco Mazzucchelli, who gave evidence, and Susan Kilsby were much more senior bankers than either Mr. Benyatov or Mr. Rao. And the second point is...
Sorry. What is the first point? Why do we need to be told Mr. Mazzucchelli is much more senior than those two?
Well, if one is talking about what information was reasonably available to the bank, it's important to note that more senior people than Mr. Benyatov.
I don't think, did I miss it? Did Mr. Mazzucchelli feature? He was mentioned once in passing, but which is the paragraph that talks about Mr. Mazzucchelli? Is it paragraph 28?
Yes, it's paragraph 28.
So Mr. Mazzucchelli and Mr. Kilsby were informed about the attacks on privatisation in the press.
Yes.
So is that your point?
That is my point. Yes. The second point is in the paragraph at 29. It says, RR thought, so this is following May, June, DM called RRVB and told them he had to hand over to the Romanian secret police all documents in relation to Petron. DM said that CS would have to...
We have read this. What's the point you're making?
Well, it's the bit that says RR thought that Lee Goss and Gavin Sullivan were involved at this point. Now, the judge deals with that in a way that, in my submission, is totally unsatisfactory. What he does is paragraph 199 sub 2, he accepts the respondent's suggestion that somehow this means that Mr. Rao was uncertain whether he had actually informed Lee Goss and Gavin Sullivan, both of whom were in the Legal and Compliance Department. Well,
It isn't.
One of them is in the Legal Compliance Department, I'm corrected.
So what the key point is, the judge interpreted the use of the word thought,
yes, as meaning
less than certain.
Yes, and that was...
Isn't it? I mean...
Well, we say the obvious reading of that sentence is that he knew they were involved at some point, but he wasn't sure when. What he was talking about was when they were involved, not if. That's why he says he thought they were involved at this point. It can't be read as...
Remind me, sorry, I ought to have this at my fingertips, but this is the facts. I don't have this point. Did Mr. Rao give evidence?
No. I'm going to have to skip over that in view of the time, but we have made a complaint about the failure of the judge to draw...
Well, it's not a ground of appeal, is it?
It is in our ground...
Is it? Oh, sorry, let's just have a look. It's quite important if it is. Which ground is it?
It is at...
I see, it's 2C.
Yes, my lord.
Well...
Where does this lead, Mr. Chumey? I mean, looking at this attendance note, you've drawn attention to paragraph 29. Things were getting very hot by then. Is your case that at that point Credit Suisse should have pulled out, take everybody out of Romania, because it's just too dangerous?
Our case, first of all, was that they should have assessed the situation. The evidence...
Yeah, all right, well, they should have assessed the situation. The catastrophe occurred in November. What should they have done in June? Should they have said, this is too hot a potato, secret police are involved, the rule of law in this country is fragile, you've just got to pull out.
In the sort of final assessment, yes, that's one of the steps that they could have taken. And
well, no, could isn't good enough. What are you saying they should have done?
Well, they probably should have pulled out. I was going to go on to say that we know from Mr. Mazzucchelli's evidence that they'd had a problem in 04-05. We saw this yesterday in Russia, and their decision was to withdraw from the mandate. In other words, never mind the possibility of making some money out of this. This is getting too hot. And Mr. Mazzucchelli was very clear. That it's not just a question of the employees. The bank stands on its reputation, and these kind of affairs.
You're not answering my Lord's question.
The answer is yes, that they should have done that. Well, that's at least, but the first stage would have been, they never even got to the first
yes, but
stage.
That doesn't get you anywhere unless, having conducted a risk assessment, what they ought to have done is assess they should have pulled out.
I just don't accept that, my lord. The duty was to assess the risk. They should have assessed the risk at that point, indeed earlier.
But you wouldn't have a cause of action if they'd assessed the risk and the outcome of the risk assessment was it's no problem about Mr. Benyatov continuing to visit.
No, but they didn't. There was no dispute that they never assessed the risk.
No.
I'm sorry, maybe I'm being dense. The point is that step one was to assess the risk. If they had assessed the risk, it's clear from the evidence that one of the things they could have done and should have done was to remove Mr. Benyatov and the others from the situation. There were additional things.
Just one small point on that. Does that we say removed from the situation? Does that mean say they shouldn't go to Romania? I mean, they could, in principle, have been prosecuted in their absence.
They could have been, yes.
Anyway, I'm sorry, this is me rather taking over my Lord's line of questioning, but I don't know whether you want to take it further.
Well, it wasn't. No, I just had a single question.
Yeah.
They should have done that. My point is they could have done, there may have been other steps they could have taken as well, but they never even got to stage one, which was to assess the situation and decide what to do.
Yeah. But sorry, this is all spinning off your ground, which is that the judge, I just want to see how this fits in. You say the judge applied a subjective as opposed to an objective assessment. And we'll have to look and see whether we agree that that happened.
Yes.
But this actually isn't addressed at this point. This is addressed to your next point, which is that if he had conducted an objective assessment, the note that you have just shown us demonstrates clearly that there should have been a risk assessment.
Yes, I suppose so. I was about to say that.
Well, what you say, you suppose so. Maybe not. Why are you taking us to this material? It doesn't. The material taken us to doesn't have anything to do with the judge, with the error you say the judge made. I'm assuming you were taking us to it because you were going to the next step of saying it would have been different if he'd approached it rightly. Have I not got that right? So I just want a route map in my mind.
Yes, and I'm not giving Your Lordship one, which is not at all helpful.
No, well, no,
That's
I'm
why
not being critical. I'm just wanting
get
help.
a grip. Well, then it doesn't have anything to do with subjective assessment, but it's still a good point. The point is, was there a warning flag? Yes, it's blindingly obvious there was.
Yeah, okay. I think it probably does fit in, actually. I help you. I think it does fit in the way that I thought that I was putting it. I thought you were taking us to this as part of your submission, that if he had looked at it the right way, i.e. an objective assessment, this material is your best evidence, maybe there's others, but this is what you've taken us to, that shows that they should have conducted an assessment. That's the point, isn't it?
Yes, if you conduct it, if you look at it objectively and ask yourself the question, what information was reasonably available, there's only one answer on the material we've got here.
Now, is that your submission on? Is there more you need to say on the first of your 3 points under ground one?
No, Okay, right. Mr. Legg comes to my rescue yet again. He points out that at paragraph 213, it's crystal clear that the judge is making a subjective assessment, because he says in the middle of that, there is no suggestion of what the bank knew or what they knew about the Romanian secret police was involved. So he's not looking at it objectively. And yes, that was my point number one.
Yep.
There are other points, but I've just picked one as an example.
Well, we will take the other points in your still so far as necessary, but that presumably you chose because it was your best point, clearest point.
Yes.
Yeah, okay.
Assumption of responsibility.
Yes.
I'll deal with this very briefly. There's some law on this, but in my submission, I don't think it's particularly helpful to start trawling our way through it. We deal with this at paragraph 28 of our skeleton. What I was going to do was just mention the authorities. The relevant passages are sidelined and not go to them now to save time. It's not like reading some of the cases yesterday. They're modern cases. One reads them and it's obvious what is being said.
Well, hang on, they're not all that. Well, some are, some aren't. But I better just flag up. It's up to you how you deal with it. But I have not understood the law to be that assumption of responsibility is the touchstone in all cases when asking whether or not there's a duty of care. I happened hook when I read this part of your skeleton. I remembered the recent lecture published by Professor Stapleton in 3 essays on torts, where she devotes some pages to the question about assumption of responsibility. And her view, and she gives case law in reference, is that it is actually not very helpful because it's simply descriptive, and that there is plenty of case law that says it's simply one element. She referred to, and I don't think this is in the skeleton arguments, and that's why I'm drawing your attention to it, in the decision of the House of Lords called Customs and Excise Commissioners and Barclays Bank, 2006, UKHL 28. And in particular, several observations, but the fullest is in Lord Roger, who looks over several pages at the question of the role of the assumption of responsibility in this area. Now, you say you don't want to go to law, and that's fine, but I just want to flag up that I myself am not persuaded that the right way into deciding whether there is a duty of care is simply to ask, did the bank assume responsibility for, quite how you put it, but effectively for protecting Mr. Benyatov from the risk of arrest or conviction. that is not a helpful analytical tool.
I will attempt to answer that by reference to one of the cases I was going to refer to.
Yes.
If we look, please, in bundle A5 at tab 73, it's at page 2073 of that authority.
Tab 75, did you say?
73, my lord. And it's 2073 in the using the page numbers.
The Privy Council did not report it as a surprise, but if it isn't, it isn't.
Well, it is.
It is.
It might not have gone into the bundle. It's recently reported in 2022 3 weeklies.
I see. Well, look,
261.
2022 3 weeklies. What page?
261.
Okay, well, we've got it in this version, so let's look at it in this version. But thank you. Which paragraph are you taking us to?
Well, it's
page?
just paragraph 60.
Yep.
I take your lordship's point, but the Privy Council here, this is a joint judgment of Lord Hamblin and Lord Burrows, are saying, well, there is debate about it, but nevertheless the courts have continued to apply it and find it useful. And I'm not going to go through...
Okay, well, that's helpful. I will... So that in a sense, and it's obviously later than the authority I referred to.
May I just ask a follow-up question? Of course, I understand the concept is still used, but there has been at least a suggestion by some people that it's to be properly understood in the context of negligent misstatement cases. But you say it's a broader foundational principle than that.
I do, my lord, and I
Does RBS support you in that proposition?
I was just going to check my note to make sure I've got the right case. Yes, it is RBS that supports that.
I thought it was, but do you want to show us the right passage?
It's in the I think it's in the sideline passages. So it's in the sideline passages. I'm just looking for where. So they start at 61. It's at the bottom of 2073. They're referring back to this case called N and Pool, which we don't have, but endorsing that.
But our case today is not a case of pure economic loss, is it?
It's not. It's a case of specific economic loss. But the reason why we say it's relevant is because, in a sense, well, if one looks at paragraph 224 of the judgment, we say it flows from that. The judge was saying that there wasn't proximity here simply because Mr. Benyatov was an employee of the bank. There had to be something more. And so we say, well, then that's the approach. So be it. But then one has to look at the question of was there an assumption of responsibility. That's in the judge's judgment at page 153.
Which paragraph?
It's paragraph 224, my lord.
Clearly, in one sense, there was proximity. I mean, it's employer-employee relationship. One understands that. But isn't the crucial question, which the case law identifies, what type of damage are you undertaking a duty of care to avoid? And there we come back to the fundamental point that, of course, health and safety, yes, so you avoid personal injury to the employee, but generally speaking, the employer is not a guarantor against future loss of earnings. That's pure economic loss.
I agree, but that's why you need to address the question of whether there was an assumption of responsibility in relation to this economic loss. And I think, and the judge is saying, well, you don't answer that question simply because of the employee situation. You have to go further than that. But then my complaint is, I agree with your lordship, but go further. Well, that must mean you consider assumption of responsibility, and he doesn't. And I make that good as follows. He directs himself at paragraphs 112, with this quote from the Greenway case, and 117. Those refer to assumption of responsibility, but beyond that, there just isn't any analysis of that issue. His focus is solely on reasonable foreseeability, and that is a serious error of law, defect in deciding whether there was a duty of care. That's really the point. I've got one additional point to that, but that's really it.
Mr. Goulding says in his Stolen argument that not only did you not put the case this way below, which, speaking for myself, I wouldn't regard as the end of the world. Often cases are reformulated a bit on appeal, and if it's a point of law, it doesn't really trouble anyone. But it goes further than that. You had initially pleaded the case in terms of assumption of responsibility. I haven't got all the details in my mind, it's just what I've read from the Stelliston. And that you, in fact, amended the pleading to not to plead it in that way. Has he got that right?
No.
Or maybe it's a point for reply. We'll see whether Mr. Goulding focuses on it. He can take us through his objection. Let's not waste time on it now, but I just flagged it up. I noticed that there was an issue about whether this point is even open to you. But you say it is. Why don't you deal with it when after Mr. Goulding has developed it?
I will. Before I do that, I will just mention, in the RBS case, a pleading point was also taken. One sees that the Privy Council say, well, it wasn't pleaded, let's look. I mean, it wasn't evidence, it was assumed fact in that case, but let's look at the assumed fact. We still do the analysis. It doesn't matter that it's not pleaded. But he's also wrong in his assertion that I somehow withdrew the point. The only additional point I wanted to add to this is, and in a sense it almost answers what your lordship just asked me about, was that if one looks at the judgment in paragraphs 249 to 268, there is a long analysis. Perhaps we don't need to turn to it, I can just explain the point by paragraph number. There is a long analysis of the bank's risk assessment machinery. Yesterday I said that we had pleaded that part of the reason for the implication of the indemnity, and we also rely on it in relation to assumption of responsibility, is that it's the organisation, and it's exceptionally the case in a bank where the whole focus of the business is to be very concerned about risk. It has a huge internal machinery of committees.
So one would expect. I'd be amazed if it didn't.
Yes, but and there was an issue at trial about, well, who was responsible for evaluating risk? Was it Mr. Benyatov or the bank? And the trial judge decided that it was the bank, in essence. But my point about that is that that long analysis appears in the judgment at 249 to 268. It's clearly relevant to the issue I've just been talking about, assumption of responsibility, but it follows his conclusions on duty of care. His conclusions on duty of care are at paragraphs 224 to 227, and then again at 245. And my submission is that suggests that he didn't take account of that material in reaching his conclusion on the duty of care. So that reinforces my submission about the failure to address assumption of responsibility.
So can I just take you back to what is the relevance of assumption of responsibility conceptually in this case? You say they assumed a responsibility to do what? That they failed to do?
So
What is it they assumed responsibility to do?
to protect Mr. Benyatov from the harm of a conviction.
But how?
How would they do that, my lord?
Yes.
They would do that by monitoring the situation, by conducting risk assessments which inform whether what action they take, should they withdraw from a mandate, should they withdraw people, and so on. The reason I'm talking and looking for something is because in the judgment there was evidence about the kind of things that the bank did after the events, and that's important. We say in answering your lordship's question, what, but how? You know, what could they have done? I'm just looking for that. It was. Yes. This isn't a full answer to what they could have done. The risk assessment, getting external advice if they needed it, was important. But if one looks in the core bundle at it's tab 5, page 107, the judge there records the evidence.
Which paragraph, the judgment?
It's paragraphs 63 and 64. I'll just very briefly explain what that's about, and then maybe your lordships wish to read it at your leisure. There were two witnesses just giving their evidence there. Mr. Gail de Boissard was in fact the most senior person to give evidence at the trial. He was a former main board director of Credit Suisse, and he gave evidence for Mr. Benyatov. One of the points you'll notice is 63 sub 2. He said that there had been a historic problem, he said. There didn't seem to be much sharing between the divisions. So there was a process failure in the bank that, for example, we're about to, in a minute, look at the Berkey document. That information came to fixed income, and there wasn't a great deal of sharing of risk assessment. And then at 64, we've got Miss Joyce Solomon's evidence about some of the steps that the bank introduced after the events that befell Mr. Benyatov and his team, which include keeping a watchful eye on a developing situation, so you're able to make decisions about deployment of personnel, withdrawal from mandates in the way that Mr. Mazzucchelli had mentioned earlier. So that's my answer to your lordship's question.
Mr. Chairman, I can see that when one is asking, was there a breach of the duty of care, that this evidence may go to that question. But logically, prior to the question of breach, is the question of whether there is a duty of care in the first place.
Yes.
And as I understand it, your criticism of the analysis given by the judge when he was answering that question was that he failed to analyse it in terms of the concept of assumption of responsibility.
Yes.
Yeah. But I'm afraid it's my fault. I at the moment, I'm not understanding what, if anything, analysing it through the concept of assumption of responsibility would have added to the way he did analyse it, which was in classical terms of reasonable foreseeability and so on. Because you say they assumed a responsibility to protect the appellant from the harm of conviction.
Yes.
You assert that, and we'll have to assess whether that's right or wrong. But in what way did they assume that responsibility? Doesn't that just bring us back to the question, should the law impose a duty of care on them to do that? In what way did they assume that responsibility? Obviously, the natural way would be through a contract, where you agree, for consideration, that this is what you will protect somebody from doing. Now, you're not asserting contract, so you're saying there's an assumption of responsibility in some other way, but I don't understand in what way. Other than for you to say the law should impose that responsibility on them, which is a different point. But that's not assumption. That's just the law saying this is what you've got to do.
I see that. I'll try and answer it like this. There may be other factors, but the key factors in relation to whether or not they'd assume this risk were, one, they were sending Mr. Benyatov to places, and it's not just Romania, places like Russia and so on, where they knew from Mr. Mazzucchelli's evidence there was a risk to their business and therefore obviously to their employees, where there were unstable political environments. Two, they had huge resources, not just internally. They had a machinery that was supposed to be looking out for risk, but they also had huge resources at their beck and call. Mr. Munir's evidence, and it's actually in the supplemental bundle, is that in the event of something happening, they'd immediately be on the phone to people that they thought could help, and his suggestion is they'd immediately have been on the phone to John Major. That's the kind of power that the organisation has. And the third point that I say is relevant to them assuming responsibility is that this duty is not a one-sided duty. It's not a duty just for Mr. Benyatov. It also works for their benefit in two ways. Their business reputation is highly damaged, as Mr. Mazzucchelli mentioned, and it's recorded in the judgment, by these type of events. And their business reputation is key. They make that very clear in their internal documents. So it's to their own benefit to try and avoid their employees getting into trouble. And second of all, in terms of reputation, and in another way, in terms of having effective employees, what they ended up was Mr. Benyatov not being able to perform his approved function. And they kept him on and paying him to do nothing. That is not an ideal way to be running your business. So if you want to have effective employees and preserve your reputation, those are factors that...
That's going a long way. All this is interesting, but it's nothing to do with assumption of responsibility, is it? There are reasons why there ought to be a duty of care. And they're the sorts of things the judge looked at.
Yes,
He just didn't use the label assumption of responsibility, possibly because it wasn't terribly apt for this particular exercise.
Well, the fact that they've got the machinery to do it surely does go to this. If I've got the ability and I have the resources to do it, and I say...
Well, that might be a reason why it's reasonable for the law to impose a duty of the kind you're alleging. Look, this needn't all... It's you who's made this all about assumption of responsibility. Your challenge, the error of law you're alleging by you're addressing... Sorry. The error of law you've chosen to identify in the judge's reasoning is about assumption of responsibility. Really what you're saying, I think, is that even approached on a conventional way for the reasons you're giving, the judge ought to have held that the duty of care, which after all the employer owes to its employees generally to look after their welfare, up to a point, extends to this sort of risk.
Yes.
Don't see what that's got to do with the assumption of responsibility, but I do see it's a point. I mean, it did occur to me, what do you think about this, that really a way of looking at the duty you're alleging is to say it is simply an aspect of, or maybe Mr. Goulding would say an extension of, that broad duty which is inherent in the relationship for an employer to look after their employees. Now, that's typically in terms of health and safety, not typically in terms of preventing economic loss. But given that he was arrested and put in prison and the rest of it, one might have said that came within their ordinary duty of care.
I agree, my lord, and
That's not the way you've challenged this in the grounds of appeal. maybe we won't hold you to that, but it's got nothing to do with assumption of responsibility, it seems to me.
It goes wider than that. I see that.
Anyway, well, it's been a useful discussion. Again, I'm just noticing the time.
Yes, right. That actually brings us to Rian, because that's in a sense the approach that Mr. Justice Carr took. I appreciate there was a very different factual situation in the Rian case. I would, may I
Speaking
just...
for myself, I haven't, I'm afraid, looked at the Rian case. I looked at it, but it seemed it's the kind of case we need some help with. It's quite long.
It is. In order to
It has
assist,
no head note.
yes, it's not reported that I'm aware of. What we've done is there's a Westlaw summary of the case, which is like a head note. If I'm permitted, please could I hand that up?
Yes, please do.
It is tremendously useful, because not only does it summarise it, but it also tells you where to find all the relevant bits within the rather long authority. The actual authority is in bundle A5, tab 67.
Thank you.
In order to understand what happened, the easiest thing is to read what's described as the abstract, bottom of page 1.
One moment, sorry. You'll bear in mind, of course, that we're not bound by this in any way, obviously, and therefore we should be looking at it simply for statements of principle. Yeah. Okay. Where is the abstract? Yes, I see.
Now, I put it forward simply as a road map.
Let me read it. Yes, thank you.
And there were two duties which concern the court. I'll just, using this document, the first was the so-called safety duty, which was found not to exist. And this was related to Mr. Rian's fear for his personal safety should he return to Dubai and so on. But the judge found that that duty didn't exist.
Forgive me for interrupting you. That being quite important. That seems to be a point against you, because as I understand it, the argument in that case was that traditional duty to protect the safety of the employee extended to protecting the employee from future financial loss. The judge held, no, it doesn't. But the judge went on to say the audit duty did arise.
Yes.
And the respondent's point is, yes, but that's to avoid unethical and unprofessional conduct by the employer, not by a third party's activities. That's the fundamental point, as I understand it, you've got to meet.
Yes, my lord. I'm going to try to do that.
But the fact that the judge held that there wasn't the safety duty going so far as to protecting an employee from future financial loss, it may be thought is quite important. That, on the face of it, that appears to be a point against you.
I see that, my lord, but I'm not sure I agree, because the safety duty in that, the focus of that was the argument was about whether it was the duty to protect Mr. Rian from physical harm should he go back to Dubai, and that's rather different to our situation.
I see.
Well, it isn't, is it? I mean, the first thing that was done to Mr. Benyatov was he was wrongfully arrested and held in custody for weeks or months. Why is that different? Your case on duty of care seems to me to be, well, one, perhaps he shouldn't have been sent to Romania at all, at any rate to work on privatisations, because it's simply too dangerous. Alternatively, when red flags began to be waved, he and the bank should have pulled out and said, we can't work him. But because of that failure, he suffers at first physical constraint and later loss of earnings. If Mr. Justice Carr is right, of course, as my lord said, it's not binding either way. Why isn't the safety duty the same?
Well, because the duty we're alleging here relates to the conviction. It's the conviction that creates the career loss.
Well, this begins to mesh with the limitation point. You have chosen to plead this as a duty to avoid conviction, but that doesn't make any sense, does it? If there wasn't a limitation point, you would certainly have been saying that one of the principal harms you'd suffered from the breach of the duty to take care would be that you spent you were wrongfully arrested in the middle of the night by the Romanian secret police and spent 2 months in a Romanian jail. It's then that arrest leads to a prosecution, and the prosecution leads to a conviction. But they're all consequences of the breach of the same alleged duty to take reasonable care for your safety. And you can't artificially cut off the bit that is and say, oh, well, we're only complaining about the conviction. Sorry, whatever ground it is, but it's a connected point.
Yes, no, I entirely see that. I was just thinking, let's deal with that now. That's in effect ground 3. But let's deal with that now. I mean, the answer is that it's not artificial. I had 2 points on that. Your lordship is adverting, as I understand it, to the judge's conclusion at paragraphs 297 and 300 that somehow the focus of our claim was artificial, and the answer to that is no, it's not. The duty alleged was not to expose him to criminal conviction in the performance of his duties. It is that caused the career loss, and that is entirely consistent.
That's true, but the career loss is only part of the loss. It's not the only damage you suffer from breach of duty.
Well, then that becomes rather circular. It goes back to what the duty being alleged is. And
well, it's clear the duty being alleged is to prevent from conviction, but that doesn't mean that you're entitled to plead it that way if actually the only viable duty is a broader duty to protect from harm, of which conviction was only one of the harms.
Well,
I mean, if I can ask you rhetorically, would your client have been entitled to complain that the arrest was a consequence of a breach of duty by Credit Suisse?
yes, if that's the way he wanted to formulate his claim, but that would have had to be a claim brought many, many years ago. And the real loss that he was concerned about was the loss of his career. It's not artificial to formulate the claim in the way he does. First of all, it's up to him how he wants to formulate his claim. Second of all, our understanding of our position in relation to the law, and we rely on Caparo to this effect, is that you can't have a duty of care without identifying what is the loss that's said to be protected against. And the loss that we assert needed to be protected against was the loss of his career. And that's why it's pleaded in that way. It's not artificial. For your Lordship's note, that is Caparo, which is in bundle A2, tab 23, page 464.
I know about this, Mr. Chinley, but what are you saying that the bank failed to do after, say, the end of 2006? And all the failures that you allege seem to me to be, perhaps they shouldn't have sent him to remain in the first place, but they failed to heed this warning flag, that warning flag, and the consequence was that, shockingly, on the 23rd, 24th November 2006, armed and masked men turn up at his hotel and drag him off, and a lot of other consequences follow. But all the negligence, all the breach of duty, which you allege, has happened then. So the cause of action in tort has crystallised, hasn't it?
It hasn't until the loss, which is the subject of the duty of care, has crystallised.
But you've yourself accepted that the arrest would be a loss, which is the subject of the duty of care, Sally badly put. Same duty.
Right. Two things. First of all, if that's the way it came across, I was not accepting that he could have brought an action at the time of his arrest on the basis of the duty of care which is now alleged. He couldn't have done.
No, I wasn't asking that. Could he have brought an action in respect of a duty of care to prevent harm?
Yes, but
from the Iranian authorities?
He could have done, but that would be a different.
But your salami slicing, you're saying there's a separate duty of care. There's a duty of care to prevent arrest. There's a duty of care to prevent prosecution. There's a duty of care to prevent conviction. There's a duty, and no doubt you could do different bits in between. But that's a purely tactical division of what is, if it exists at all, a duty of care to protect him against harm from the foreseeably risky situation into which he had been put, effectively harm from the Romanian authorities.
I don't accept that it is salami slicing because his career wasn't in jeopardy merely by being arrested or by being arrested at gunpoint. That didn't.
But it often happens, doesn't it, that in a duty of care situation, some loss occurs early, further loss occurs later, and maybe, well, it must have been predictable a bit, otherwise it wouldn't be foreseeable loss, but maybe it wasn't in everyone's mind at the time that the first loss was suffered. For that reason, for example, that in the context of extensions in personal injury cases, you can get an extension if the loss turns out to be more serious than you thought at first. But the cause of action accrues as soon as there is some loss, even if it's less than the loss that occurs much later.
No, as a general proposition that might be, but that doesn't work here for two reasons. The loss that he may have suffered earlier was not a loss of career. And insofar as he suffered any of that loss, our second point, which is in our skeleton, is that was effectively a contingent liability, if that's the way you want to look at it. But it wasn't. He wasn't at risk of losing his career by the earlier events. No one thought that would happen when one looked at the evidence. Credit Suisse had taken the position in support of Mr. Benyatov. He was doing no more than an ordinary international businessman would do. And it was evident in the documents we saw that everyone was shocked by the outcome. So the initial events were not going to give rise to the loss event that the duty of care we rely on is based on. I don't think I can say...
No, thank you. That's been very helpful.
Any more than that.
I see exactly what you say about it. Now, we got into that arise out of questions on Rehan, but I don't think you'd yet had a chance to show us the bits you wanted. Just before you do that, I'm not going to stop you now. If we were being very strict and holding you to your deal with Mr. Goulding, we would say you've now had your half of the morning session, but you've had rather more. Given that it's normally easier for a respondent to it takes less time for a respondent to respond because so much of the ground is covered. Speak for myself, but I think for my lords also, we'll give you a bit more time, but we now really do need to know how much you think you need. How much ground have you still got to cover?
Well, I wasn't intending to break my agreement with Mr. Goulding. What I was going to do was to take off time from my time for reply if I went past 11 o'clock today.
Well, one way or another, we needn't bother about whether it's a breach of your agreement with Mr. Goulding. I just wanted a clear, the best indication possible of how much longer you're likely to be.
I shouldn't be that much longer. I wanted to say one more thing on the point we were just discussing. I then have to deal with Rian. In terms of ground 2, I've picked one sole example.
Good. Okay, well, that's fine. I've just put down a marker, and let's keep going.
I just, before we leave the point about the issue of ground 3, the claim not being told, I had two other things to say. One, the judge's job in my submission is to deal with the case as pleaded. It was wrong of him to say, well, this is all rather artificial. It's the case as pleaded that is before the court. And secondly, the judge's findings, and he made this clear.
Sorry, just on that point, I don't want to go on about it, but there is authority, isn't there, to which he referred, which says, if in truth your cause of action has accrued more than 6 years before the start of the proceedings, you can't artificially get around that by pleading only the loss and a cause of action relating to the loss that's occurred within the limitation period. Isn't that what that authority says?
I don't dispute that, my lord, but that's, as I I'm not going to repeat myself. As I was saying, that isn't the situation here.
I see. Yeah, okay.
The,
Because you say this is a separate duty.
yes.
Yeah, okay.
And I was just going to say that in the judgment, for your Lordship's note, paragraph 1, 41 to 42, that's where the judge made findings about the removal of the FCA authorisation. And therefore it's simply not artificial to say that that is when the relevant loss event in terms of this duty was.
Yeah, of course the loss, most of the loss is post 2013, post 2015. But that doesn't answer my Lord's question about when the breaches occur.
I thought I'd accepted that the breaches occurred when your Lordship said,
Yeah.
but that the loss occurred later, and in terms of limitation, that's the key point. We did have allegations in relation to events post-arrest in the original particulars, but that was part of the case that was struck out.
Yeah.
And Mr. Benyatov was not in a position to appeal that decision.
Remind me, was it struck out because of limitation? Was it?
No, limitation wasn't.
Yeah, I know limitation in relation to the surviving claim was only pleaded later.
Yes.
I just wonder whether that was the reason why.
No.
Okay.
Your point, I think, is that damage is an essential ingredient of the tort of negligence. And so it's not the date when the breach occurs that the tort crystallises, it's the date when damage occurs.
Absolutely.
So that leads into the debate, which I'm not going to rehearse again. As my Lord put to you earlier, there was some damage earlier. You say that doesn't matter because the only damage you're now claiming for is the loss flowing from the conviction. That's the critical event.
Exactly, my Lord. Let's go to the Rian case and look at the audit duty in that case. The decision is in bundle A5 tab 67, and the audit duty starts at page 1901. I think the easiest way to do this is to invite your Lordships to read 3 paragraphs there, and then we can turn to see what the judge in our case did. There's the sideline paragraph 616, paragraph 617 underneath, and then over the page, the sidelined paragraph of 621, please.
Very well. We need to read 620, don't we? Otherwise we don't know what question he's answering. Yep.
So before we turn to the judgment, I just wanted to make a point about 621 in answer to a point raised earlier by my Lord Singh. The audit, as I read this anyway, the audit duty which was found to exist arose in Mr. Justice Carr's mind also out of I don't want to say the safety duty, but the duty generally to protect employees. So that is, in my submission, helpful to us. We can see how the judge, in our case, dealt with it by looking at the judgment, paragraph 151, please. That's core bundle, page 132.
Still without the judgment, but if you tell me what it said,
I was going to analyse it fairly closely.
Oh, in that case, should someone just pass me up that page? Some junior will have to sacrifice their copy. There'll be a reward for the one who gets it to me first.
It's a race.
I claim my reward.
It is a draw, so I won't have to decide what the reward is. Let's just have it.
Doesn't really matter. Either one, that's fine.
Yep.
Thank you.
Thank you. Yes.
There are 3 points I want to make about this paragraph. Does your lordship need a moment just to read it before I...
Yes.
Which paragraph here?
It's 151, my lord. On
Yeah.
Page 132.
Well, it's the point my lord put to you earlier when we were first talking about rehab. That's a duty about how the bank conducts its own affairs with integrity, and therefore it's quite like Mahmoud or Malik, as it's sometimes called.
Yes,
Yes.
I tend to call it Malik. The first, I'll make my 3 points. The second sentence in my submission, the judge is wrong about why the cases are analogous and why Mr. Justice Carr referred to Mahmoud in Rian. The audit duty does not provide assistance. In Rian, first of all, there wasn't a claim for breach of contract because he was a partner, not an employee. So the implied term of trust and confidence wasn't at issue in that case at all, which is what Malik or Mahmoud was about. And at 617, we saw that Mr. Justice Carr said such a duty...
Is this your first point still?
It is, yes.
Yeah.
First point focuses on the second sentence of paragraph 151. At 617, Mr. Justice Carr, in talking about the duty, his audit duty, said it closely mirrors the content of the portmanteau trust and confidence. But in my submission, what he then goes on to, he goes on in the balance of 617 to explain what he means by that. And his focus in my submission is on the consequences of a breach of that term. He talks about the ability of the claimant to resign and claim constructive dismissal. He doesn't say it, but he's just been talking about Malik. And the point of Malik was, if there was a breach of that implied term, it avoided the limitation on damages for wrongful dismissal of just your notice period. You could claim for stigma damages or career loss. So his focus there in 617 is the impact of a breach of that implied term on the employee. And the judge, in our case, was wrong to focus on whether there was a similar fact situation between the Malik case and Rian. The point is the legally significant factor was what Mr. Justice Carr says at 617. That's my first point. The second point relates to the third sentence of this paragraph 151. It says, the one beginning, in the instant case, there is no challenge to the integrity of the business of the bank or its practices. In my submission, that misses the point. Apart from the fact that their negligence in conducting their business, on our case, exposed Mr. Benyatov to conviction, the point is that for breach of the implied term, moral culpability is required. But we're not talking about the implied term here. We're talking about an implied duty of care. And moral culpability is not required. The focus of the duty of care is on protecting the employee from the loss. For your Lordship's note, that is also covered. It's paragraph 18 of James Bowen. The bundle reference is A4, tab 56, 1363. I'm not going to turn to that. I'm certain.
James Bowen, para 18.
Para 18. I'm no doubt we're going to be looking at that case later, so I won't turn to it now. It simply reinforces the point I'm making. The difference between the implied term requires moral culpability, duty of care. That may be part of the fact situation, but it's not relevant to the duty. And so my third point on this was that the judge was wrong to dismiss the analogy I drew. He says, Mr. Chume submitted there was an analogy because Mr. Benyatov had been tainted with a finding of criminality affecting his career. That isn't a difference at all. One has to think about the fact situation in Malik. In the Malik case, if one looks at the head notes, but the facts I'm guessing are fairly familiar to your Lordships, the reason why Mr. Mahmood and Mr. Malik said their employment prospects were tainted and they wanted stigma damages was because the regulatory authorities had made it known that they regarded the BCCI business as a corrupt business. Now, that is that they were tainted because in that case the assessment, and one could call it a judgment, it's not a legal judgment, of a third party, the regulatory authorities became known, widely known. The taint arises not because of the conduct of the employer, but because the conduct of the employer becomes known externally. And so it was, whether or not what I'm trying to say is it doesn't matter for the duty of care whether or not there's moral culpability on the part of the employer. What matters, because the focus is loss, the consequences to the employee, what matters is the employee is tainted. In Mr. Benyatov's case, he is tainted because of a conviction by the Romanian authorities. In Mr. Mahmood and Malik's case, they were tainted.
I can see, Mr. Chume, how you would put that argument if you accepted that the convictions were right. In other words, the employer has engaged in unlawful conduct and has required its employee to engage in unlawful conduct. Then I can begin to see an analogy. But your fundamental case is that nothing unlawful was in fact done. The conviction is a travesty. So why does an employer have a duty of care to avoid that?
Because, well, my answer is in two parts. First of all, whether or not it's a travesty, it's a fact, and it's a taint in real life on Mr. Benyatov's career. And because if we are right about the duty, however unlikely Mr. Benyatov had been placed in a situation where that was a possibility. It's not just that our case was that there was a risk of prosecution. Because of the circumstances in Romania, if you were at risk of prosecution, your your jeopardy was very grave because the justice system doesn't function very well there. So once you fall foul of the authorities, you are potentially in big trouble. And so, I may be losing my thread. What I'm trying to say is it doesn't depend upon the conviction being correct in order to mount our case. I don't know if I've made that very clear. But
No, you have.
before we leave this, one other point, I just wanted to make the point, and again for your Lordship's note, it's bundle A2, tab 23 at page 464. The whole
This is an authority.
It's an authority.
Which authority is it?
It's Caparo again. It's just to say that, and it's just, perhaps it doesn't, it's the obvious point I've been making. The focus of the duty of care is on loss. It's on the consequences. You don't have a loss, you can't even begin to bring
On the
your
type of loss. That's your fundamental point.
Yes.
You don't just have the duty in the abstract.
Exactly.
The scope of the duty of care is integral to the question of whether you impose a duty of care.
Yes, my Lord. May I just speak for a moment with Mr. Legg? I had, in view of the time, if possible, I had one other point.
Yes.
And I was just going to, it's my 1 point under ground 2.
Yes.
Which will require us really just to look at a couple of the documents.
Yes.
And ground 2 is the failure, we say, to take account of relevant and material evidence.
Yes.
And to reach conclusions not reasonably open to the judge. I appreciate this is a high standard. We've accepted that in the skeleton.
Yeah.
The one example that I was going to give was what is called it's the interview note of Mr. Berkey. It's of the same type as Mr. Rao. It's part of the investigation.
Where do we find it?
We find it in supplemental tab 4, page 15.
Yes.
My points are twofold. One, it was wrong of the judge to find that this was not a warning flag.
Sorry, I didn't hear that. Speak up. Wrong of judge to do what?
Find that this information was not a warning flag. And two, it was wrong of the judge to find that the bank had no knowledge of it.
Which information? Sorry.
The information about the investigation by the SRI into what we say was the bank. In the judge's list of flags, this was flag number 5.
Very well. What's your
flag number? I'm sorry. I can't
Should you not
remember.
take us through the bits that matter before you make your submissions on it?
I will.
Now
I
you've
will,
found out what they're going to be.
Yes, I will also correct what I just said because I can't even read my own note at the moment. It's flag number 6,
Okay.
not flag number 5. There are, just to mention, in our skeleton at paragraph 38.1.2, we set out
38 point.
38.1.2.
Yeah.
we set out the evidence of both parties' experts that this amounted to a significant event.
Yeah.
I'm not going to turn to that, it's set out there. And I think really that the easiest thing is just to invite your lordships to
read the whole note.
yes,
Okay.
read the whole page,
Brilliant.
including, it's helpfully at the top, it gives everyone's titles, and the KS is Mr. Stud there, but it says he's not just in general counsel of a particular region, but he's also reputational risk approval.
Well, we can see that, yes. Should we not just read it?
Yes, please.
Yes.
I've got one point of background and then I'll make my point on the document. Mr. Berkey's in FID, fixed income. That's a different division, it doesn't say it, but Mr. Benyatov is in the IBD, the investment banking division. That's a completely separate part of the bank. The point on this is simply that the judge concluded at paragraph 616 that this...
No, hang on, forget. Turn to 616.
Did I say 216? Forgive me, 216, which is page 150 of the bundle.
Just read it.
It starts at the bottom of 150, goes over the page to 151. And his conclusion is at the end.
Yes, thank you.
My point is simply this. That conclusion is unsustainable when one looks at the document on its face. It's clear that the bank knew. The document records, it says in paragraph 1, the file was being compiled in Romania on Stamem, Stanchev and CS. And we are told in the second line that the frontier consultant told CS. In other words, they told the bank. Mr. Berkey is not recorded as saying, they told me. There's nothing in here to suggest that he'd...
Hang on 1 second. Okay, thank you.
And the judge actually found earlier that they'd informed the bank. At least that's what he records in his judgment, and that is paragraph 202 at page 148.
What do you say about paragraph 2 of the note?
In what sense?
Well, the judge says twice that the note shows that Mr. Benyatov was unconcerned about the issue.
I'd say the following. One, that's not an answer to whether there's a duty of care. The question is, one of the questions is, what information was reasonably available to the bank? Mm-hmm. The fact that Mr. Benyatov wasn't concerned about it doesn't mean that the information wasn't available to the bank. Clearly it was. It's obvious on the face of the document. That's point number one. Point number two was that the evidence at trial, for example, by Mr. Mania, was that, and also from some of the experts, was that Mr. Benyatov is a banker focused on the transaction. He wants to do deals. Mr. Mania described him as very good at that, but not someone, and he meant this as not someone with a very good strategic overview. So that's what the senior management is there to do, is to stand back and say, hang on a minute, what's going on here? The whole point, it's inherent in the risk assessment machinery that the banks have, is that you have to have independent oversight of bankers actually trading or conducting transactions at the front line, because they tend to have a very blinkered view of what is and isn't important. The only thing that matters to them is doing the deal. So that was his view. But in a sense, so what? It was clear that he was not. The bank tried to say, oh, well, it was all down to him. That simply was not true. It can't be the way you run a bank. You simply can't say, well, the person doing the transaction has the final say on whether it's a good idea or not. That's the route to disaster if you're a bank. So that's my answer to it. Yes.
We got the answer, yeah.
Yes. It's a fact, but it doesn't answer whether there's a duty of care, and it's not an answer to Mr. Benyatov's claim.
Was any question asked of any witness about who in CS Frontier Consultants had told?
Well, we didn't have Mr. Berkey wasn't called to give evidence. But there's a general point.
Was there any other Credit Suisse? Was any other Credit Suisse witness called to give evidence? Or rather, I'm sorry, there was. Was any other Credit Suisse witness asked about this, even though Mr. Berkey couldn't be? I'm not being critical. I just want to know. I just want to know whether there's any other evidence or any exploration at the trial of who was told.
In the absence of Mr. Berkey, it would be very difficult because the bank.
No, so just answer my question.
I can't recall. I may, and I've no doubt that the respondents, with their fantastic legal team, will be checking the transcript now. I may have asked Mr. Studd about it. I simply cannot remember at this juncture. That would have been the only person that you could have asked. But may I just say this? The problem is yes, he has a role as general counsel and reputational risk approver. That's within IBD. It's not within FID.
Mr. Toomey, had you finished on that particular point?
Yes,
I wanted to take you back, if I may, to page 151 in the judgment. If you have page 151, it's in the middle of paragraph 216, right at the top of the page, where the judge is asking himself the question, what are the warning flags? And he says they have to be real flags, matters that ought to have been noticed and acted upon at the time. And this sentence interested me. They have to be matters which were or ought reasonably to have been in the knowledge of the bank. Now, on the face of it, that sentence appears to suggest that the judge was applying an objective test and not simply a subjective test about what was known to the bank. Would that be a fair way of reading that?
Forgive me, my lord. You were looking at the sentence. Which of the sentences here? They have to be matters which were all
Yes.
reason.
Yes.
It might, but it just, that can't, if he was doing that exercise, how on earth could he have reached the conclusion he did, is what I would say.
I understand that submission, I understand, which is that he reached a conclusion not reasonably open to him on the evidence, but it might suggest that he did not misdirect himself as to the correct test. In other words, he recognised that it was an objective test, not subjective.
Yes, I see that, but I was going to go on and draw your lordship's attention to the next sentence where, when I would say his whole approach was just wrong, he basically set in the next sentence an enormously high bar as to whether something was a warning flag. It had to be something which would have avoided a conviction. And that's just, that meant that nothing, apart from a phone call from the SRI to say, by the way, we're going to arrest some of your employees and interfere in the prosecution to get them convicted. It's difficult to see what would ever have satisfied the judge, and that's not the way the case was put. But I'm straying beyond answering your lordship's question.
Just going back to this paragraph, I see what you say about points B and C. What about point A?
I didn't really address the pleading point. I say it's just there's some quite complicated reasoning to it, but it's just a terrible point. Even if we...
Isn't it dealt with in your skeleton?
It is, yes. It doesn't matter.
Show us the passage, because then I'm now even concerned about time. If it's dealt with there, then we can probably take it from there, can't we? Reading points tend to be complicated.
I think it's paragraph 39.
Where are the 7 red flags catalogued?
They are in the, I think is it 166?
Yeah.
No. Oh, it's 179, my lord. So that's page, in the core bundle, page 141.
Reading this reference to pleading without knowledge, I thought what the judge was saying was, if Credit Suisse had known before the trial that you were going to be relying on this passage as proof of knowledge, just talking about particulars of knowledge here, as proof of knowledge that the Romanian secret police had opened a file, they would have been, or might have been, able to produce evidence on that question. Who knows what that evidence would have been? It might have been to call Mr. Berkey after all, it might have been other evidence. Is that not why the judge referred to the absence of a specific pleading? Or have I misunderstood what he was getting at?
Well,
It's not in a sense a pleading point. It's more a point of saying that it's difficult for him to make a finding of knowledge in circumstances based on a document which wasn't relied on as showing evidence of knowledge.
I don't read it in that way. May I just ask Mr. Legg one thing? My reading of what the judge, the answer is twofold, and I'm sorry to keep saying that. But my reading of what the judge was doing was saying, well, because you didn't allege actual knowledge, therefore it is a true pleading point, and you can't rely on the fact that at trial actual knowledge was proved.
No, it's not a general point about knowledge, it's a point about pleading in advance of the parts of the document dated 24th and 29th, here we're concerned with 24th, now relied on.
Yes, but...
So he's saying, if you'd said you were relying on that statement, it could have... Isn't that the point? That it could have been investigated.
Well, yes, but it could have been investigated anyway, because we did say, if not in the pleading...
No, all right, but that is the point being made, isn't it? You may say it's a bad point, and then you've answered it in your cellars. I just wanted to understand what the judge's point was.
Yes. Yes, my lord.
Thank you. Now, just one minute. Mr. Chume, you've had plenty of indulgence about time. Is there anything else you really feel you are obliged to say and can say in a minute or two, or on the basis that we, of course, will take into account also the points made in the skeleton, have you said all you need to say?
I'll just check, I think so. Yes, the one thing I haven't touched upon at all is causation, but that's in our skeleton, and if necessary, I only had 2 points on that. If that issue arises, I can address it.
You're speaking of respondent's notice point anyway, so perhaps you can take, at least I think it is. Maybe it isn't. I'm sure you can take some comfort from that. Yes, thank you.
So those are my submissions, my lord. Thank you.
Thank you, Mr. Chume. Yes, Mr. Goulding. I'm sorry your time's been rather truncated, but I think there is truth in what I said earlier, that you don't need as much time as the appellant. Of course.
Well, just before we lose those 2 points that were raised at the end of Mr. Chume's submission,
yes.
Could I just deal with them now?
Yes, of course.
My Lord Justice Underhill asks about little a in paragraph 216 of the judgment, where the judge said, without a specific pleading in advance.
Yes.
If your lordships also look at paragraph 214 on page 150, the first sentence deals with the same point and I think answers my Lord's question rather more directly.
Thank you. Sorry, let's just, first of all, let's go back to where we were. It was 216A, that's right. And you're saying C204.
214,
214.
first sentence.
Yes, thank you. Yep.
Lord, the point in short is there was no advance notice of either of the three notes on which the appellant put so much weight at trial, the two row notes of the 24th and the 29th of November, and the Berkey note. I will come back to that if time allows when dealing with the so-called pleading point under ground 2. But
Yes.
I just wanted to
I don't want
respond
to bog you down with a lot of detail at this stage, but in broad outline, just so I can get these obviously were notes disclosed by you. What was the origin, what was the basis of the obligation which the judge refers to at 214 to provide particulars of reliance? Had there been an order for reliance on an order for particulars of knowledge, is what I used to call it? Is that there had there?
Lord, this is how it arose. I'll try and deal with it.
Deal with it in the headline, and then
yes, I will.
If you've got time to give more detail, you can later.
These notes were disclosed by us in November 2019 because they form part of the investigation that took place following Mr. Benyatov's arrest. In 2020, Mr. Benyatov sought to amend his particulars of claim to plead reliance on what became known as the flags.
When was that amendment application?
It was issued in I think May 2020.
Yeah.
It was heard on the 1st of October by the deputy judge. The draft amendment at that stage alleged knowledge of the events which we now see referred to in paragraph 55 of the amended particulars of claim, but then in much more abbreviated form. It was a wholly new amendment at that stage. We said insufficient particulars. It doesn't say who at the bank knew, when they knew, or how they knew. The judge said, I agree. Permission will only be granted upon those particulars being provided. A further draft APOC, as I'll call it, was subsequently provided, which didn't provide those particulars. There was a further hearing in front of the judge. The deputy judge gave his judgment at the end of November.
This was Mr. Tahar.
Still Mr. Tahar.
He was both.
He was, yes.
Yeah.
We took the same objection. He said, I agree, these particulars are still not provided. I will grant permission for the amendment, subject to this caveat. There is no allegation of actual knowledge being made against the bank. If something...
Actual knowledge of what?
Of the flags, so for this purpose, the SRI investigation. If there were to be such an allegation sought to be advanced, it would have to be pleaded. And any application to amend to plead it would be considered on its merits. And that was said when my learned friend had told the deputy judge that these were the best particulars that could be given at that stage because of the respondent's inadequate disclosure, notwithstanding the fact that we had disclosed these 3 documents a year previously. No such application to amend was made, and therefore, in the light of that ruling, we say we were entitled to and did approach the trial on the basis that no allegation of actual knowledge of these matters was being advanced. We had no notice by way of pleading, for example, that any of these notes were to be relied on. And as your lordships will appreciate, these are 3 short notes amongst over 7,000 pages of documents in the trial bundle, which then were cross-examined upon, the respondent's witnesses cross-examined about these notes. And the case then built that, well, the bank did have actual knowledge and did nothing about it.
And the witnesses cross-examined were the witnesses you had called, who included neither Mr. Rao nor Mr. Berkey.
Yes, because we didn't know that this issue was to be put in this way, so we didn't consider calling them. That is why the judge on each of these points in his judgment expresses it variously as no pleaded actual knowledge, no advance notice of these notes. The bank didn't have the opportunity to consider whether to call Mr. Rao or Mr. Berkey.
That's just what I asked for. That's a helpful overview. You haven't given chapter and verse. If you have time, you can. Maybe those behind you can produce literally a 1-page note giving the references in Mr. Tahar's the procedural history with the cross-references to Mr. Tahar. That will save you having to do it. But it's all there in the supplementary bundle if we choose to look, is it?
My lord, it is, and it is in our skeleton.
And in your skeleton. I'm sorry when I didn't remember it was there. Pleading points are often not the ones one follows up most.
Of course. Lord, it's paragraph 50 under the heading Statements of Case through to 57.
Well, if what I just said I would like from the juniors is already there in the skeleton, don't do it again. But
Lord, I hope it is, but we'll review it.
okay.
And just to explain this, well, this is so central to ground 2, where there's an attack on the judge's findings in relation to the red flags. And so whilst the so-called pleading point is the second of the 4 points Mr. Toomey raises under ground 2, we've addressed it as the first point because it is critical to have that as the context for the criticisms then made about the judge's approach to the red flags. I hope that's helpful.
No, that is helpful. No doubt will slightly shorten what you're going to do when you come back to it later. Right.
Lord, the second point I just wanted to address, if I may, was my Lord Justice Singh's question about 216 to Mr. Toomey just at the end of the submissions. And I'm sure the court will have picked this up, but Mr. Toomey invited my Lord's attention to the sentence that suggested the judge had set the bar very high in saying these matters, if registered at the time, ought to have been acted upon in a manner which would have avoided a conviction Your Lordships will have seen the rest of the sentence or reduced the chances of a conviction. So I just wanted to make sure that the court had the rest of that sentence in mind. The bar wasn't set only as high as would have avoided the conviction.
Mr. Goulding, was either Mr. Rao or Mr. Berkey among those employees or former employees of Credit Suisse who were told that their non-disclosure agreements prohibited them from speaking to the claimant's solicitors?
No.
Is that standard practice nowadays in employment litigation?
Lord, I don't know what standard practice is. I wouldn't want this court to have the impression that the matter was quite as simple as that. I can go into it in more detail if necessary, but this arose very late in the day, on virtually the eve of the date for disclosure or exchange of witness statements, when approaches were made to these witnesses. And the matter...
When you say these witnesses, not including Ryan Birdie?
No, these were the three witnesses called by Mr. Benyatov.
Yes, I remember.
Gail de Boissard, Miss Solomon, and Mr. Munir.
Yeah.
They were ex-employees. There was correspondence about it. The bank were considering the position. Were there in fact NDAs? Did they prevent the individual speaking? What should the response of the bank be? But because this was raised at the 11th hour, just before exchange of witness statements, those matters weren't fully resolved, and Mr. Benyatov proceeded to issue witness summaries. So I wouldn't want your Lordship to think that it was simply that the bank said, you have NDAs, you cannot discuss this case with Mr. Benyatov or his advisors. There was a more complicated procedural history than that. My Lords, may I begin by way of overview? In our submission, the appeal should be dismissed for three principal reasons. First, it is largely an appeal on the facts, which falls a long way short of satisfying the strict test that would permit an appeal court to interfere with a trial judge's findings of fact. In short, the judge's findings were reasonably open to him. As the court has seen, the appellant's pleaded case is that particular facts and matters gave rise both to the duty of care and to the implied...
So is this a development of your first point?
This is the first point.
Yeah.
Same facts and matters gave rise to the duty of care and indemnity. That's the APOC Paris 24 to 26. And as the judge put it in 107, the judgment, there was a common factual substratum to justify both the scope of duty of care and the scope of the duty to indemnify. The judge considered a vast sea of documentary and witness evidence and made his detailed findings, which, as he put it at 245, was that major building blocks on which the claim was based were not established. And as he said in terms, the claim failed on the facts. See, for your Lordship's note, Paras 227 and 245 on duty of care, 365 on the indemnity in fact, and 369 on both claims. Secondly, insofar as the grounds of appeal raise points of law, they're without merit. Ground one, assumption of responsibility, relies on an alleged error by the judge in not adopting a test which he was not invited by either party to adopt, which we submit is not the proper test, and which, even if applicable, is not satisfied. Ground 3 on limitation involved the judge applying well-established principles which are not challenged to the appellant's own evidence on loss. And ground 4, the indemnity in law, is wrong for the powerful reasons as described by the judge in 326. And third, in order to succeed, the claim requires the court to take a big leap to introduce a major extension of the common law, which would be contrary, we submit, to principle and to precedent and to policy.
Sorry, is that in both in relation to the indemnity issue and the duty of care issue?
Yes. Lord, let me then just spell that out briefly. As to the negligence claim, the alleged duty of care is in respect of pure economic loss of earnings, resulting from the wrongful acts of third parties, the Romanian authorities, allegedly caused by an omission by the respondent, a failure to carry out a risk assessment, in circumstances in which the loss was not, as the judge found, reasonably foreseeable. To recognise such a duty, we submit would be inconsistent with the analogous authorities and also with the incremental approach, which is customary or characteristic of the common law. As to the indemnity claim, it's without precedent in the 400 years of case law before the court on indemnity in agency and employment relationships. It would, if it exists, have provided a simple remedy in many cases where claimants failed to recover against their employers, and indeed would have provided a simple remedy in cases where claimants succeeded, but through the more complicated route of proving negligence. It would eclipse tort law, requiring textbooks on employer liability to be rewritten. And it would, as the judge found, be likely to impose huge burdens on employers of all sizes, resources, sectors, the precise nature of which, with respect, a court cannot foresee, such that it's a change, if it were to be made at all, that should only be made by Parliament, not by extending the common law. Well, that's why I say in both those respects it would require a major extension. Well, that was...
factor is whether the sorts of risks that employers would then be undertaking would be insurable risks.
Indeed.
Might not matter to Credit Suisse, who can afford very large sums, but
Yes.
might matter to other employers.
Lord, indeed, and Mr. Justice Freedman alludes to that, the question as to whether they would be at all insurable.
And yet, I'm sure you can see why Mr. Benyatov, on the basis that he did absolutely nothing wrong, which is the basis on which the trial was mostly conducted and what the basis which the judge found, feels very aggrieved that he has lost his career, quite apart from all the other very bad things that happened to him, simply for doing the very job that he was employed by you to do. That's why he says it's a question of who bears the risk of such a thing happening.
Well,
It has an instinctive appeal.
Well, we understand that entirely, which is why the bank has sought to support him ever since his arrest. As you will have seen, as the court will have seen, the bank has spent in the region of £10 million in fees supporting Mr. Benyatov and the two other employees who were also convicted in terms of legal costs and other fees for advisors on what steps could be taken.
Some of those, on a conventional indemnity basis, I don't know if it's a concession you want to make, but one might have thought they were obliged to pay anyway.
Well, they have paid them.
Yes.
Lord.
Well, I'm sure they have, but I don't think it's inconsistent with your position to concede, that you might not care to, that they were actually obliged to pay them, but they are, let's try and find a negative word, let's find a neutral word, obligations of a very different character from an obligation to pay loss of earnings.
Well, to respectfully agree, it's not inconsistent with our case. Should there be the obligation to pay legal costs, but an obligation to indemnify in respect of future loss of earnings is of a different character altogether.
Well, the mistake is, well, I'm not sure. I mean, this is one of the areas, not now, but just flagging it up, but I would want help on. How does one characterize the distinction? You say it's a very different kind of obligation. But where is the line drawn? You said future loss of earnings, but it can't depend on the happenstance of exactly at what point the claim is made. After all, by the time it came in front of the judge, quite a lot of them were past loss of earnings. So it's more a question of loss of earnings or unliquidated loss of earnings. I don't know. That's what I want some help on.
Well, my Lord, I wasn't seeking to make a time point there.
No.
It's the loss of earnings was the
Yes,
point I was concentrating on. And we say there is a difference of nature or quality between what the indemnity covers and what it doesn't cover. The rationale, we say, for covering payments that are made is that employees are not required to do their job at their own expense, out of their own pocket, covering those costs, paying for things which arise from the performance of their duties, whether it be paying a third party pursuant to a judgment, paying legal costs to defend certain claims. Employees shouldn't be out of pocket in that way. That is different in nature and quality than an indemnity covering sums not received in the sense of lost earnings by the employee.
Yeah.
The way in which it was put, certainly below by my learned friend, recorded in the judge's judgment, is that the indemnity is to make sure that employees are no worse off as a result of their employment. We say that is not a proper rationale for the indemnity. A contract of employment is not a contract of insurance. The employer is not a guarantor that the employee will be no worse off as a result of the employment, but the indemnity ensures that they won't be out of pocket, having had to spend money of their own to do the job.
Well, okay, it's helpful to have a quick headline answer. You'll develop that later, no doubt. Yes, now, is that the end of your overview?
Well, my Lord, what I wanted to do was just say a little about the proceedings below. I'm, of course, conscious that the court has read the judgment, but it does seem to me that there are some details in what happened below, both pre-trial and at trial, that it would be helpful if I could summarise for the court to have in mind.
No, speaking for myself, I think that would be helpful. It's the sort of thing, it's not easy to pick up just from reading the judgment.
Well, my Lord, can I endeavour to do that?
Yes, I mean, I don't know how long that'll take, but why don't, if we do that section and then break for lunch. Yeah.
Also, there are three stages of the proceedings below, I want to touch on the pre-trial stage, the trial, and then the judgment. First, the pre-trial stage. There were two significant interlocutory stages pre-trial, and they're relevant to the appeal because they show the time that was spent considering what the basis of the pleaded duty of care would be, which is, of course, relevant to the criticisms now levelled at the judge's approach. The first of the two interlocutory stages was the application to strike out. It was heard over 3 days in December 2019. That gave rise to extensive argument and citation of authority regarding both negligence and indemnity claims. And the parties argued about whether the respondent owed the alleged duty of care and the basis for it. There was citation of authorities such as Robinson and James Bowen at that stage. And at that point, the negligence claim fell into two distinct chronological phases. First, the appellant pleaded that the respondent breached the duty of care by failing to carry out a risk assessment prior to the arrest.
Hang on one second. Do we have the amended particulars of claim in their original and in their various stages?
Yes, we do have some, Lord.
Well, okay, I don't, unless you want to, don't take them student now.
For your Lordship's note, supplementary bundle tab 11 is the original particulars of claim.
Yes, I see.
And supplementary bundle tab 15 is part of one of the draft versions of the APOC.
The strikeout application was to strike out the whole claim.
Yes, it was.
Thank you. And I'm sorry, because I just asked a question about the pleading. I didn't note down what you said, that the negligence claim was pleaded in 2 stages.
Yes, two chronological phases. First, that we breached the duty by failing to carry out a risk assessment prior to the arrest. That survived the strikeout.
Hang on a second. Yep.
Second, that the respondent breached a duty of care by failing to take steps to intervene with the Romanian authorities after the arrest. That was struck out. So the court has heard references to the respondent should have engaged some international statesperson to intervene and so on. That was struck out. So that was the strikeout application. The second important interlocutory stage concerned the amendments to the particulars of claim. Initially, the appellant produced a draft amended particulars during the strikeout hearing, but didn't make an application at that stage, but applied for permission to amend after the strikeout judgment. It was a protracted process. The application, I can see now from my notes, it was made in April 2020. I think I said earlier in answer to my Lord's question, May, but it was, application was issued in April 2020. And there were a total of 8 iterations of the draft APOC before the one that was finally served. And the amendments included extensive amendments to the applicant's case on duty of care. Permission was finally given in December 2020 for the APOC, and an amended defence was served in January 2021. In fact, as the judge says in para 89, deep attention and preparation went into the case. And my lords, it may be helpful just at this stage to turn.
So the APOC that we got in the core bundle is obviously the one for which permission was eventually given,
Yes.
and you have, no doubt, because you want to make particular points on it, given us one of the many iterations that preceded it. That's at 15. So, yeah.
Yes, for a particular reason, because that goes to the so-called pleading point. It
Yes,
shows
okay.
how what's now para 55, the red flags, was first introduced. Lord, can I invite the court's attention to the APOC, which is in core bundle at tab 12, just so one can see its structure and some of the contents. There are 6 main headings. The first is the introduction, that's paras 1 to 8. Then parties at 9 to 10. And then the third heading, page 253, obligations owed by Mr. Benyatov, to Mr. Benyatov by the defendant. Now this is subdivided first as obligations under the contract of employment. That's paras 11 to 20, which is of course where we find the para 19, indemnities. 19.1 was there from the start. 19.2 was added by way of amendment in December 2020. 19.3 over the page alleges an implied term of the contract containing the duties pleaded at para 24 below, owed in parallel in contract. So what's being said there is it was an implied term of the contract that the respondent owed.
Sorry, which paragraph are we looking at?
19.3.
Yes, I see, of course.
So it said, respondent owed in contract, as an implied term, the duties of care also owed in tort. That was introduced by way of amendment after the strikeout, because one of the points we took at the strikeout is where the parties' relationship is governed by contract. You can't have a duty of care in tort that goes beyond a contractual duty. Of course, you can have duties in contract and in tort, but the duty in tort is at least unlikely to be any greater than the duty in contract.
Yes.
See Lord Justice Sales in Greenway, which is cited in the judge's judgment.
So I'm not picking you up, but just as to you called that added after the strikeout,
Yeah.
but actually it was added, formally it was added in December 2020. There's only been one amendment.
Yes, there has.
Yes, but if you cared to do the archaeology, you could see some bits of it came up earlier and some later.
Yes, exactly so.
Okay. Okay.
And then there are 2 sections, which we really needn't spend time on, but just to explain, there's a heading, the letter dated 1st of December 2014, and oral assurances above 23. They might seem strange to the court reading them now. What was originally said was that the letter and the oral assurances gave rise to legal obligations owed by the respondent to the appellant. The judge struck out the allegation that they gave rise to legal obligations. So these sections remained in the pleading by way of background, but not giving rise to legal obligations. That's why they're there, sitting now rather oddly in this section. There then follows the heading above para 24, duties of care in tort. And that was extensively amended, para 24, in December 2020. And the final subdivision of this section is the heading above 25, facts and matters giving rise to the duties of paras 19 and 24. And it is important just to see what's being said here. I think the court has this point at 25. Facts and matters giving rise to the implication of the terms referred to in 19.1, 2 and 3 as a matter of fact. I'm not sure that and or business efficacy adds anything. And giving rise to the duties at para 24 include the following. So all the matters in this paragraph are said to be those relied on supporting both indemnities at 19.1 and 19.2, and at 19.3 the implied duty of care in contract, and at 24 the duties of care in tort. and those are the 23 sub-paragraphs of paragraph 25. And just to highlight some which feature then significantly in the judgment, 25.6 was said that various Russian connections of Mr. Benyatov increased his risk profile. 25.14 is Romania being a high-risk country. 25.15, high-risk transactions. 25.21 states the test for implied terms. Effectively,
So sorry, just one moment. Which one? After 25.15, where are we going?
25.21, yeah, effectively states the test for an implied term, in fact. And 25.23 states what was said to be standard procedure at the time for risk assessments. And 26 then deals with the facts and matters giving rise to the implications of the terms as a matter of law. So all of those matters that we've just seen set out in 25 are also relied on as supporting the implied terms in law, the indemnity and the duties of care in contract. See 26.1. Save for 2 subparagraphs. So that's why I said earlier, all of the facts and matters relied on in support of the duties of care and the implied indemnities lay at the heart of the case. And the judge failed on the facts. 27 to 28 then says that certain risks should have been known to the bank, and if the court looks particularly at 28...
And the actual heading under which this is all pleaded is facts and matters giving rise to the duties.
It's still facts and matters,
yeah.
Yeah. At para 28, your lordships will see about halfway down that paragraph on page 264, a sentence beginning further or alternatively. Now, this was introduced by way of amendment in December 2020. It was said the defendant could and should have been informed about such risks by engaging with, for example, and the court will see, UK embassy employees based in the relevant embassies in Bucharest. I've skipped a few words in between, but...
Yeah.
And then employees of the EU delegation in Romania.
Yeah.
And I draw attention to that simply because, as your lordships will have seen, the bank called as witnesses the British ambassador who was serving in Romania at the time, that's Mr. Quayle, and also the head of the EU delegation who was in Romania at the time, Mr. Shaler, principally to answer this allegation where it was said, well, you should have informed yourself of the risks at the time. And it was argued, if you had done so, you would have been told that there were these high risks. And both of those gentlemen gave evidence to say that they didn't consider that Romania was a high-risk country. But the judge summarises their evidence and finds that it was of considerable weight. And then the fourth section begins above para 30, and this is really just the appellant's chronological narrative, and it goes through to para 50, where the heading is, the fifth heading, breaches by the defendant. And we see particulars of breach above para 51. 51.1 is a breach of failure to indemnify. Interestingly, that the plea here is for his losses incurred as a result of his arrest and or conviction, para 51.1. And then 52 is breaches of duties of care, and 52.1 is essentially failure to carry out the risk assessment, and one sees at 52.1.2 failure to engage with embassy officials and the EU delegation. The third is failure to give adequate consideration to the suitability of Mr. Benyatov conducting the business in Romania, and the fourth is Mr. Stanchev. And then 52.2 is essentially what became known as the flags, the red flags. And this was new at the amendment stage. And perhaps for the court's note, 52.2.1, Rom Petrol, was flag 2. 52.2, Mr. Stanchev, was not pursued at trial, as the judge notes in his judgment, so no findings. That's see para 188 of the judgment. 52.2.3, this is the anonymous letter to Linklaters about Rom gas. That was flag 3. And 52.2.4 sweeps up flags 4 to 7. The adverse press coverage of Petron was flag 4, and the interest of the Romanian secret police, flags 5 to 7. The language of flags is not used there. Of course, that only really emerged at trial. And then 52.3 through to 8 breaches are really parasitic on the earlier allegations, particularly 52.2.1, effectively sending Mr. Benyatov to Romania without having carried out a risk assessment, 52.6, failing to advise him about the risks, and so on. 52.7 was the new allegation of breach that was directly linked to the 19.2 indemnity. And then finally, remedy is the sixth and final heading, covering the remaining paragraphs. Well, I hope that's helpful just by way of overview.
Yes,
of
it is.
the
And I
APOC.
see the time. I don't know whether that's actually brought you, you still haven't got to the end of your summary of the proceedings below.
No.
I think we probably reached a natural break.
Yes.
Speaking for myself, I think this sort of ground laying is helpful. So feel free to continue it after lunch. Now, I think we will sit again at 1:15. Well, that will give you sufficient time to get something to eat. Thank you.